I'm Drew Stevenson, and this is a lecture for my Statutory Interpretation and Regulation class about the case National Labor Relations Board, or NLRB, versus the Catholic Bishop of Chicago. This is a 1979 Supreme Court case about avoiding serious constitutional questions, or what we sometimes call the canon of judicial avoidance. And the idea here is that when the court is interpreting statutes, it should try to resolve cases and interpret the statute in a way that sort of dodges constitutional problems or questions if they can. This can be a little counterintuitive if you're a law student and you feel like the fun part of being a judge would be to make these big constitutional rulings, but we actually sort of have a rule against that judges are supposed to avoid disrupting the established case law and constitutional law, or creating new con law precedent, or maybe we're really trying to avoid a showdown between the courts and Congress, if they can, when they're interpreting a statute. And now, this thing we call the avoidance canon has gone through a few different variations and iterations from the courts. And that's part of why we're reading this case, is that it brings to the foreground two different versions of how to apply this constitutional avoidance or judicial avoidance of constitutional questions when they're resolving cases. And there's a prologue to the Catholic bishop's case. Just so you know, the classic expression of the avoidance canon goes back to an old case called Ashwander versus Tennessee Valley Authority, or TVA. And that's a case where the Supreme Court struck down a federal statute on the grounds that it violated the Constitution. This case doesn't really matter, the facts of the case, for our purposes here. What really mattered about Ashwander is that Justice Brandeis wrote this really fantastic concurrence that became the famous part of the case. He agreed with the result that the majority reached, but he thought that the statute already favored the petitioner. The case could have been resolved on the merits without reaching the constitutional question. And so Justice Brandeis's concurrence brings us something called the Ashwander Rules. And I'm nowhere, we haven't gotten to the case at hand yet, but as part of being well read in statutory interpretation, you should be aware that there are these things called the Ashwander Rules, and it usually comes up in questions about judges trying to avoid constitutional questions in their interpretation. Now, in his concurrence, Justice Brandeis listed 7 principles, or 7 Ashwander rules, that he had extracted from a long line of Supreme Court opinions over time that would help avoid ruling on constitutional questions. Most of these, 5 of these 7, are super specific things that you are unlikely to ever encounter in practice. But the 4th and 7th Ashwander rules really frame our discussion in modern times for the avoidance canon. So the reason I'm talking about this is there's a sense in which whenever we talk about the avoidance canon, it all goes back to the Ashwander rules, and specifically Rule 4 and Rule 7. So here's Rule 4. This is the principle that courts should resolve questions of statutory construction first, and then only proceed to constitutional issues if they have to, if the resolution of the statutory questions does not resolve the case. Sometimes people call this the last resort rule of avoidance. And the idea is, if you can resolve the case on the merits, with a straightforward application of the statute, or maybe picking the interpretation of the statute for an ambiguous one that dodges the constitutional question and saves it for another day, then why wouldn't you do that? By the way, there's sort of a procedural corollary to this that courts really seem to use in practice, that if you can resolve a case on technical or procedural grounds without reaching the merits, you should do that too. And so you'll see a lot of opinions, especially in your civil procedure class and other procedure classes, where the court addresses jurisdiction or some other the procedural posture of the case, and basically dumps the case on procedural grounds without even really getting into the dispute between the parties. And they prefer that because it helps bring stability to the body of case precedent. And they especially want to do that when we come to constitutional law. And again, this could be so that constitutional law, because it's the foundation of everything, so we want it to be kind of stable and not disrupted constantly. It could be to kind of restrain judges from being too activistic or legislating from the bench, or it could be to avoid a showdown and a constitutional crisis between the judiciary and Congress. But the idea, the original fourth Ashwander principle, I hope you can see here, is really a process or workflow or decision tree question. Notice it's the order in which you address the issues. So please think about that the classic or old-fashioned avoidance canon was arrange the questions that you have to answer in a case like in sort of a flow chart. And if you can resolve the settle of the case before you get to the constitutional question, do that. Right? So this assumes sort of a progression of thought or workflow through a case when you're adjudicating it. Now, the seventh rule says when the validity of an act of the Congress is drawn in question, and even if there's a serious doubt about the constitutionality, the cardinal principle is that this court will first ascertain whether a construction or management of the statute is fairly possible, by which the question may be avoided. And this is what we call the modern avoidance canon, which is you really have a duty if you can interpret a statute to save the statute from being invalidated on constitutional grounds, you should do that. You could frame this as sort of a presumption of constitutionality. So here we're not just picking the interpretation, but we're really trying to find a way to construe the statute so that we can save it. And this is a little different than the workflow question or what we call the last resort rule, where you reach the constitutional question last. This is if you can see that there's going to be a constitutional question, you should really, really it should be a high priority for courts not to go around invalidating congressional enactments willy-nilly, but only do it when they have to. Now, here's our statute. In this case, we're finally going to talk about NLRB versus Catholic bishop, and this is Section 8 of the National Labor Relations Act, which says that basically protects the right to form labor unions or engage in collective bargaining for workers, that they can band together and unionize. And it's an unfair labor practice for an employer to interfere with the rights of workers who want to organize into unions or to refuse to negotiate with a duly appointed union representative. In other words, the point of the National Labor Relations Act was to protect workers' rights and specifically their right to unionize. Now, the dispute in this case is about a set of Catholic high schools in Chicago that provide a secular education as well as religious instruction. So if you're a student in one of these schools, you do have your religion classes where you learn Catholic doctrine and practices and history and heritage, but you're also going to learn reading, writing, and arithmetic. And the lay teachers at these schools, and by the way, what that means is these are not ministers. They're not monks or nuns or priests or clergy. They're just teachers, and the teachers may or may not even be Catholic. And they're hired to teach subjects like math and social studies, not religious subjects. And those teachers at these schools wanted to engage in collective bargaining and form a teachers union. And the Catholic bishop said, you can't. So the teachers went to the National Labor Relations Board, which of course it implements and administers the National Labor Relations Act. The board has statutory authority to recognize unions, give them legal status as legitimate employee representatives, and basically its statutory mandate is to protect unions' rights so they can order legally the management to recognize a union of the employees and to deal with them. The idea here is to level the playing field, right? So that each individual, when they go and they want to ask for a raise or better benefits or better working conditions or more vacation time, it doesn't have a very good bargaining position with the management. They can just say, no, we'll fire you and hire someone else. But if the workers can band together and unionize and threaten to go on strike, it levels the playing field a little bit, and they might have to give and take or trade. Okay, we don't have to get a raise this year, but we want better benefits or something like that. But they're going to bargain as a group, and that is better for the whole group overall. That's the idea behind the act. So the teachers, as I said, had asked the NLRB to recognize their union and tell the bishop that they were going to engage in collective bargaining over things like salaries and benefits. And the bishop said, you can't do that because it's unconstitutional, because we're a religious school and the National Labor Relations Act can't apply to religious organizations. And depending on your perspective, you can either see this as a clear example of the free exercise of religion and avoiding trying to recognize the free exercise clause of the First Amendment, or you could see it as a religious organization basically saying that they're just above all law, that the law doesn't apply to them for how they treat their workers. So the bishop says that if you apply the act to religious entities, it'll interfere with the right to free exercise of religion protected by the First Amendment. And in a way, there's a little bit of a slippery slope argument here. Like, where's it going to stop? Are you going to tell us who we can ordain as priests, or who's allowed to do sacraments, or and things like that, and interfere with our religious beliefs? But the real question in this case was not about priests or clergy or even the church itself. It was about educators who teach exclusively secular subjects like math. And so the National Labor Relations Board said these aren't religious workers, and they're not even teaching religious doctrine. They're just teaching math and social studies, so they get to unionize. If you're going to have secular employees, they're on the same status as everyone else. The fact that the employer is religious doesn't mean that they're above the law. Well, the court doesn't want to touch this, right? They really don't want to even deal with the question in this case. So they avoid ruling on whether applying federal labor law to religious organizations would violate the First Amendment. They don't say it would. They don't want to answer the question of whether it would. And this is important because it kind of highlights the distinction between classical avoidance and modern avoidance, which is a bit more aggressive. So in this case, and other questions involving modern or strong avoidance, the court really aggressively construes the statute to avoid deciding, actually even confronting this difficult constitutional question. And I've tried to present it. I hope you can see the arguments on both sides, that we really don't want the secular government if we're going to allow religious organizations to have schools. And that's really been a longstanding traditional part of a lot of religious groups, is educating their young people in their values and norms and heritage and so forth. So we've kind of always done that. And so if we're going to start meddling in that, where's it going to stop? And on the other hand, these are just math teachers, right? So the we're going to avoid saving, we're not trying necessarily to save the statute from invalidation on constitutional grounds. And the way to think of this is the classical avoidance was save the statute, right? Interpret the statute in a way that saves it. And here what the court is doing is like, we don't even want to get to that step. We're going to bend over backwards to interpret the statute so that we can pretend there's not even a constitutional issue here. Now, from a textualist standpoint, you're really in trouble with this statute, because it doesn't really leave an exception for religious employers. It's really hard plausibly to argue textually that the word employer in the statute wouldn't include a religious organization that hires teachers to teach secular subjects in their schools. Now, let's get to the fun part of the case where we have a dispute between the justices themselves about which version of the avoidance canon to use. We have a weaker one used by Justice Brennan that says the court can avoid a constitutional issue by looking for an ambiguous term in the statute and picking the interpretation that doesn't mean we're violating the Constitution. In other words, if you could write out on the board or a flip chart 2 or 3 possible interpretations of a vague statute, and one of them avoids a constitutional crisis, of course you're going to pick that one. But there's a stronger version of the canon that the majority seems to use here that basically says even an unambiguous term, but maybe a broad term. So it's not vague, it's just a broad term like employer. We're going to just assume that it doesn't include something that would be problematic. In other words, unless Congress is going to spell it out that they really wanted to have this showdown with churches and religious organizations, which they didn't do. So in other words, we're sort of going to adopt a strained reading, not the plain meaning and not even the very plausible meaning, to avoid a constitutionally problematic thing. And again, this is partly based on the idea that if Congress wanted to do this, they wouldn't have left us guessing about it. They would have spelled it out. And so now please keep in mind when you're in practice as lawyers that even though the stronger version of the avoidance canon plays out in this case, other courts, even today, still apply the weaker approach in other cases. And I'm going to give you a very recent quote from the US Supreme Court about this. But first, I want to hit up the Sutherland Statutory Construction. This is the big famous treatise about how to interpret statutes. If you're going to quote something in a brief someday other than binding case precedent, Sutherland's is kind of the prestige thing to quote about statutory construction. It's available on Westlaw, by the way, and searchable. So here's the thing about his statements about the avoidance canon. Courts presume legislation is constitutional. That's step one. So we work with a presumption that Congress didn't intend to violate the Constitution. And so we should resolve any doubt about the validity of a statute or amendment in favor of sustaining it. In other words, we should try to save a statute if we can, and sort of give statutes the benefit of the doubt constitutionally and not be quick to overturn statutes as unconstitutional. That's the first part here. The second part is this important corollary, which says maybe even avoid having to answer the question about whether the statute is constitutional by interpreting it in a way that isn't really a constitutional problem, right? So if you have two interpretations and one is kind of like, wait, what about the Constitution? And the other isn't, why don't you pick the one that there's no problem? The fact that one among alternative constructions involves serious constitutional difficulties is a reason to reject that interpretation and in favor of a reasonable constitutional alternative. So if we divided our class into 2 sections and said, okay, each side argue a different possible interpretation of this, of some ambiguous statute, then we're going to kind of give bonus points to the side that doesn't violate the Constitution, or maybe hold it against the side whose interpretation does. Now, he also notes, Sutherland's now notes, the latest edition, that courts have found that a strained construction is fine if it's the only way to save the act's constitutionality. Now, I told you I wanted to give you just a quick quote from the Supreme Court about the current status of the avoidance canon and how they take it. This is from the United States v. Davis in 2019. I'm not going to tell you about the facts of that case, but they had this footnote in footnote 6 that says there's at least 2 different canons of construction that sometimes go by the name constitutional avoidance. And so I really want my students to understand this, that the Supreme Court is saying that there's kind of 2 things that are called the same thing, that avoidance canons out there. The one the government invokes here is perhaps a better term, the presumption of constitutionality, or what we might call the last resort rule of long lineage. In other words, this is a very old rule with a good historical pedigree. It holds that courts should, if possible, interpret ambiguous statutes to avoid rendering them unconstitutional. And then This is distinct from the more modern and more debatable constitutional doubt canon, which suggests courts should construe ambiguous statutes to avoid even the need to address serious questions about their constitutionality. And then it cites a case, Rust v. Sullivan, which is also in our casebook. Okay, quick review question. What's the difference between strong avoidance and weak avoidance when a statute presents a constitutional issue? A, weak avoidance favors whichever plausible interpretation avoids the issue, and strong avoidance will strain the reading to avoid the issue. Or B, weak avoidance just gives in and holds the statute to be unconstitutional, and strong avoidance never gives in. So hopefully you know the answer to that. This wasn't supposed to be a hard question. It was supposed to see if you were paying attention. And if you're not sure about the answer, you should rewatch this video about NLRB versus Catholic Bishop of Chicago.